Okay. Looks like everyone is here. Today, we are going to learn about the U.S. copyright law. What do you know about the U.S. copyright law?
Nothing.
We do not need it.
In the ideal world, perhaps. But, in the United States, we need the copyright law, for several reasons. Let's look at the U.S. Constitution because any law that's enforceable in the United States must be authorized somewhere in the Constitution.
It is noted in the Constitution, under Article 1, Section 8.
Is that so?
Okay. Let's take a look at the U.S. Constitution under Article 1, Section 8 to see if he's right. Did you find anything related to the U.S. copyright law?
Heck, yay. According to the Article 1, Section 8, the Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries.
Can someone dumb it down?
In the lamest terms, the Constitution is telling us that we must allow people to make a living by using their creativity to come up with writings and inventions that can generate income for them.
Right. We must.
Heck yay.
Yeah. We should.
Definitely.
If you read the U.S. copyright law, you will find out that copyright owners have 6 exclusive rights.
What do you mean by exclusive rights?
By exclusive rights, we mean the rights belong to the copyright holder and to no one else, unless transferred by the copyright owner. Can anyone guess what those 6 rights may be?
To make copies, so you can make a living by selling copies of your work.
In other words, it is to reproduce the copyrighted work in copies of phono records.
How about making spin-offs or sequels, like they created the Cleveland show out of Family Guy? Yes, that's one of them.
In other words, it is to prepare derivative works based upon the copyrighted work.
How about selling copies?
How about renting copies?
How about lending copies for free, or even giving them away?
Yes, they are all part of the third right.
In other words, it is to distribute copies of phono records of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending.
How about public performance or showing, like music, comedy acts, poetry recitals, and movie showing?
Yes, they are all part of the fourth right. These copyrighted materials you've just mentioned are designed to be performed publicly rather than just being read. And the owner of the copyrighted work is the only one who has the right to perform it in public.
In other words, in case of literary, musical, dramatic, and choreographic works, pantomime, and motion pictures and other audio-visual works, it is to perform the copyrighted work publicly.
How about paintings and sculptures? If someone wants to put on a show to display my creations, he has to get a permission from me, yes?
Yes, that's correct. Only the owner of copyright can legally put on a show to display the work in public.
In other words, in the case of literary, musical, dramatic, and choreographic works, pantomime, and pictorial, graphic or sculptural works, including the individual images of the motion picture or other audio-visual work, it is to display the copyrighted work publicly.
How about digitally transmitting the copyrighted work publicly, like playing songs over the radio, sharing MP3 and videos on the internet, or by satellite?
Yes, that's the newest right that was added.
In other words, in the case of sound recordings, it is to perform the copyrighted work publicly by means of a digital audio transmission.
Make sure you write down these 6 rights on your notebook or iPad.
Professor, I heard there is a time limit on copyright. How long does copyright last?
It's 70 years, right?
It is actually the life of the author, plus 70 years.
Right. After which time, the work becomes part of the public domain and can be used by anyone without permission.
Wait a minute. 70 years. Why 70 years?
I suppose 70 years would be long enough for heirs of the creative person to continue to gain the profit from the person's work for a couple of generations beyond his death.
Oh, you've got the point there.
Indeed. But, remember, this only applies to the works created after January 1st, 1978.
What about the works created before 1978?
Yay. What about those?
That's your homework to find out.
Man.
Professor, what do I need to do to create the copyright? Is it similar to obtaining a patent?
No. Unlike patent, the work is automatically copyrighted as soon as it is created in tangible form.
According to the Section 102 of Title 17, United States Code, copyright protects original authorship fixed in tangible form.
Can you give us some examples?
Of course. Essays and papers you write in school are all copyrighted.
What about PowerPoint presentations? What about my own note-taking?
What about my YouTube videos?
What about the graffiti I painted on a wall the other day?
They are all copyrighted.
What about the advices that I give people every day?
Are they recorded on video or audio, or in text?
No. They are not.
Are your advices presented or performed in public like a choreograph for dancing or a script for stand-up comedy, which is often not written down or recorded, but is merely performed?
No. They are not. They are more like personal dialogues between me and people.
Then, your advices are unfortunately not copyrighted because they are not fixed in tangible form.
That is actually all right with me.
Then, classroom discussions like what we are having here, right now, are also not copyrighted.
That's correct.
What else is not copyrighted?
Ideas and thoughts would not be copyrighted unless someone writes them down or record them to fix them in tangible form.
So, my nighttime dreams are also not copyrighted.
That's correct.
Wait. My essays are usually all about my ideas and thoughts. You said, ideas and thoughts cannot be copyrighted. So, how can you copyright my essays?
You cannot claim the copyright on your ideas and thoughts alone, but you can claim the copyright on the essay itself. Merely having an idea or thought doesn't constitute copyright. Mere ideas and thoughts alone cannot be copyrighted, but the work can.
Thank you for clarifying it.
What are the consequences of violating the copyright law?
The consequences are pretty severe.
Death.
Penalties for statutory damages range from $750 to $30,000. And, if the court finds willfulness, up to $150,000 per copyright infringed. Criminal fines can be up to $250,000 or 5 years in prison, or both.
A friend of mine was fined only $200 for illegally posting a TV show on YouTube. That was probably because the court found that he honestly was not aware and had no reason to believe that his act constituted an infringement of copyright. It was an honest mistake. In that case, the penalty can be reduced down to $200 or more.
So, tell me if I am wrong. Then, there are two factors that will make the penalties higher. The first factor is, if someone is aware of the copyright law. And the second factor is, if someone makes money by copying and selling someone else's work.
And also remember, even if the person doesn't make money, copying and distributing someone else's work for free may result in a huge financial loss for the person who created the work. The court takes that into consideration when assessing the penalties. What if you were making a copy for educational purposes? Teachers and students do that all the time, don't they? Yes, they do. We are running out of time today, so we will continue our discussion and talk about the doctrine of fair use in our next class meeting. Okay, here's your homework.